I will take you through the major legal provisions set out in the Children and Families Act Part 3. These areas are SEN and health and care provision definitions, local offer and provision of information, pre-assumption of mainstream education, education, health and care assessments and plans, direct payments and personal budgets, right to appeal and mediation, schools and post-16 institutions' responsibilities towards children and young people with SEN. Children and Families Act 2014, Section 20. Who has special educational needs? A child or young person is defined as having special educational needs if he or she has a learning difficulty or disability which calls for special education provision to be made for him or her. A child or young person is considered to have a learning difficulty if she or he has a significantly greater difficulty in learning than the majority of others of the same age, or has a disability which prevents or hinders them from making use of facilities of a kind generally provided for others of the same age in mainstream schools or mainstream post-16 institutions. You will notice that there is no need for a diagnosis. However, having a diagnosis will help the child or young person secure the support they require in mainstream education settings. So what this means in practice is that if a child or young person displays signs of having a learning difficulty, such as autism, dyslexia, or global learning difficulty, then this is evidence of having special educational needs. There are several ways that a child or young person can fall under the special educational needs definition, which are as follows. A child or young person who has a global learning difficulty, i.e., a person learning at a slower pace and therefore failing to perform many milestones expected by their non-disabled peers of a similar age. A child or young person who has a specific learning difficulty, such as those with dyslexia, dyscalculia, or autism. These people have difficulty in specific areas of learning, while still being able to perform milestones of the same or above level expected from their non-disabled peers of a similar age. A child or young person who needs furniture, equipment, and materials in a format that is different from their non-disabled peers, regardless of learning ability. Some examples may be Braille, large print, hearing loops, height adjustable table and chair, assisted technology, and alike. These things will not generally be available for non-disabled pupils or students to use during their lessons. Children and Families Act 2004, SEN Code of Practice, 0 to 25 years. The SEN Code of Practice says that a person falls under one or more of these categories of special educational needs. First category, communication and interaction. For example, autism and specific speech and language difficulties. Second category, cognition and learning. For example, dyslexia, dyscalculia, moderate learning difficulties. Third category, social, emotional, and mental health. For example, autism, ADHD, and pathological demand avoidance. Fourth and final category is sensory and physical difficulties. For example, muscular dystrophy, cerebral palsy, deaf, visual impairment. Children and Families Act 2014, Section 20, SEN provision definition. Special educational needs provision for children or young people aged between 2 and 25 means educational or training provision that is additional to or different from what is generally available for others of the same age in mainstream schools, post-16, early years education, or was in a training or undertaking an apprenticeship. There is no definition of special educational needs provision, which means that is open for interpretation. What constitutes as SEN provision can sometimes be of use, such as differentiation of the curriculum, Braille machine, British Sign Language, and specialist dyslexia teacher for a pupil or student with learning difficulties, visual impairments, and hearing impairments. This is because SEN provision is clearly associated with educational need. However, what constitutes as SEN provision has broadened out to include speech and language and occupational therapy and other forms of provision. Children and Families Act 2014, Section 21, Local Authorities' duties around SEN, health and social care provision. The local authority has a duty to provide health care or social care provision which educates or trains a child or young person because it is treated as special educational needs provision. This provision has been included in the Children and Families Act 2014 because there is often a fine line between what constitutes SEN, health and social care provision. This is because speech and language therapy can be used to enable a pupil or student to speak as a result of a physical health condition. Speech and language therapy can be used to enable a pupil or student with communication difficulties to learn about language and communication so they are able to access the curriculum. The local authority has a duty to provide health and social care if it helps to educate the child and young person with special educational needs. There is no clear definition of what is meant by health care, even though speech and language, occupational and physiotherapy provision is made available in schools and colleges for children and young people with special educational needs. Mobility aids, such as wheelchairs and walking frames, may also fall under the healthcare provision definition. This is because children and young people with SEN may need mobility aids so they can actually get into the educational setting so they're able to learn and complete their courses. Without such aids, the children and young people may not be able to access learning opportunities. More broadly, this provision recognises the important role that all sorts of health interventions and health-related equipment has in improving children and young people's participation in mainstream education. Similarly, there is no definition of social care, which is often personal care that children and young people with special educational needs require to be in mainstream education setting. However, learning support assistants and other staff have provided assistance with going to the toilet, feeding or getting dressed throughout the day, in addition to providing support for disabled pupils and students during their lessons. More broadly, this provision recognises the important role that social care has in improving children and young people's participation in mainstream education. Children and Families Act 2014, Section 30, Local Authorities' duty around advice and information. Local authorities must arrange independent advice and information services for young people and parents. Local authority has a duty to publish a local offer including a list of services such as schools, children's centres, SEN assessment services, training and employment support, and alike. It is important to note that the local offer does not provide parents and young people with special educational needs a right to specific services. Children and Families Act 2014, Section 39, Pre-assumption of mainstream education and school or other institution requests. Local authorities must comply with parents' and young persons' requests for named mainstream school or other institution in educational healthcare plan unless it's unsuitable for the age, ability, aptitude, or special educational needs of the child or young person. The attendance of the child or young person at the requested school or other institution would be incompatible with the provision of the efficient education of others or the efficient use of resources. For children and young people with education healthcare plans, the starting point is Section 39 of the 2014 Act. This requires the local authority to comply with most requests for a particular school or college to be named in the education healthcare plan. If these exemptions apply, the local authority must then identify a school or college or a type of school or college that is appropriate for a child or young person. Children and Families Act 2014, Section 33, Pre-assumption of mainstream education for children and young people with education healthcare plans. The second test is for reasonable steps that local authorities are required to make a mainstream school or post-16 institution suitable. A child or young person with a plan must be educated in mainstream school or college unless it's against the wishes of the young person or parent or the provision of efficient education for others. A local authority can be exempt from offering Pacific or any mainstream school or post-16 institution if it shows that there are no reasonable steps that it could take to prevent the incompatibility of the efficient education for others. It is important to note that Section 33 does not permit a local authority to refuse to name a mainstream school or college on cost grounds. The incompatibility with the provision of efficient education for others exemption is a narrow exemption, and it can be difficult for the local authority to show that it applies. The SEN Code of Practice says, efficient education doesn't mean the gold standard of education. The local authority will have to show that the other children in the class would not receive a suitable, appropriate education in terms of their age, ability, aptitude, and any special educational needs they may have. This also includes other institutions, such as further education establishments. It is important to note that this Section 33 exemptions are the only exemptions which a local authority can rely on to refuse to educate a child or young person in mainstream settings. If neither of the exceptions is engaged, the local authority cannot refuse simply because the local authority believes that a mainstream school or post-16 institution cannot meet the child or young person's SEN, or that a particular school or post-16 institution is not suitable. This is because if there are no suitable schools or post-16 institutions with available places already, wherever inside or outside its area, the local authority is under an absolute obligation to make a school or post-16 institution suitable. The local authority thinks it would cost too much money, unlike the provisions of the 2014, which deal with which school or 16 plus institution should be named in Education Healthcare Plan. There is no exemptions to Section 33 pre-assumption on the basis that mainstream education would be incompatible with the efficient use of resources. Children and Families Act, Section 34, Pre-assumption of mainstream education for children and young people without an education healthcare plan. All children and young people without an education healthcare plan must be educated in mainstream education unless they are placed in a special school for assessment purposes or placed in a special academy that are allowed to admit children and young people without education healthcare plans. There is a strong presumption that a child or young person should be educated in a mainstream setting. This presumption is almost unqualified in relation to children and young people with SEN but without an education healthcare plan. Children and Families Act 2014, Section 35, Children with Special Educational Needs in Mainstream Nurseries and Schools. Anyone concerned with making special educational provision for the child must secure that the child engages in the activities of the school together with children who do not have special educational needs, and it's reasonable to do so and compatible with the child receiving the special educational provision to meet his or her special educational needs. The efficient education for the children with whom he or she will be educated, and the efficient use of resources. This means that schools must arrange their SEN provision in such a way that enables children with SEN to be taught alongside their non-disabled peers. SEN provision should be embedded within mainstream classroom settings. So, for example, speech and language therapy programs are embedded and taught within the curriculum offered for all pupils in the classroom. Similarly, physiotherapy programs could be part and parcel of a mainstream PE or games lesson so that the children with SEN are not segregated from their peers. However, there may be times when the SEN provision needs to be arranged outside the mainstream classroom setting. This will be determined by a case-by-case basis. There are no guidelines for schools to follow in determining when SEN provision should be incorporated in mainstream classroom settings or provided in a separate facility such as a SEN unit. Children and young people on SEN support. Child or young person needs SEN support, usually requiring a limited amount of resources that can be provided within the school or post-16 institution's SEN budget. Child or young person has no absolute right to any specific SEN provision. The SEN budget is not ring-fenced for the child or young person. Education institutions must adapt and change the support where necessary for a child or young person with special educational needs. Schools and post-16 institutions must make sure they meet the reasonable SEN of children and young people up to SEN budget allocation per pupil or student, which is set at £6,000. This does not mean that the education institutions are not required to arrange SEN provision or make reasonable adjustments if the cost exceeds £6,000. SEN support is the assessment and review process schools and other settings use to identify and meet the needs of children and young people with SEN. For more information, read the Code of Practice 6.44 and 7.13 for SEN support in schools and post-16 institutions. Education institutions must adapt and change the support where necessary for a child and young person with special educational needs. Schools and post-16 institutions must make sure they meet the reasonable special educational needs of children and young people. Children and Families Act 2014, Section 36 to 40, Education, Healthcare, Assessment and Planning. For children and young people with high levels of SEN provision, there may be an entitlement for an education, healthcare assessment and plan that will be arranged by the local authority. The local authority can financially help schools and post-16 institutions to cover the financial costs involved in securing the SEN provision for children and young people with high needs. The legal limit of completing an education healthcare assessment and plan is 20 weeks. You will notice in the slide that there are timescales for each phase in the education healthcare assessment and planning system. The stages are as follows. Education healthcare assessment requests made by parent or young person must be completed in 6 weeks. Education healthcare assessment undertaken by the local authority must be completed within 6 weeks. The draft education healthcare plan must be completed within 2 weeks. Parents' comments, including requested by a particular school or institution, must be completed 2 weeks, and then finally, the education healthcare plan must be completed 4 weeks thereafter. Children and Families Act 2014, what is in the Education Healthcare Plan? The Education Healthcare Plan should include the following information about the child or young persons. Section A, interest, aspiration, and basic view of the situation. Section B, special educational needs. C, health needs that are related to their SEN. Section D, social care needs. Section E, outcomes, including long-term hopes for adult life. Section F, special educational provision. Section G and F, health or social care provision. Section I, education and training placement. Section J, personal budget, including direct payments usage. Section K, professional advice. The school or post-16 institution is under duty to admit the pupil or student if named in the Education Healthcare Plan. One of the guiding principles in the Act is placing disabled children, young people, as well as their parents' views at the centre of the Education Healthcare Assessment and Plans, alongside the local authority's decision-making processes around the delivery of education healthcare services. The local authority, rather than the education provider, is under duty to secure the SEN provision as set out in the child or young person's education healthcare plan. And the clinical commissioning groups or the NHS commissioning board must arrange the healthcare provision as set out in the child or young person's education healthcare plan. Strategically, local authorities must consider how integration of education, health and care provision will impact upon the quality of provision and improving the well-being of disabled children and young people, covering their physical and emotional and social-economic well-being, as well as personal and family relationships and alike. Further, there is a duty placed upon the local authority to both cooperate and joint commission education and healthcare provision for children and young people with special educational needs. In practice, it should mean that children and young people with special educational needs should be able to access all the support they require to flourish within mainstream education settings. Children and Families Act 2014, Section 44, Review and Amend Education Healthcare Plans. Local authority must review child and young person's education healthcare plan annually. Local authority may reassess the child or young person. Local authority may make amendments to the child or young person's education healthcare plan. Children and Families Act 2014, Section 45 to 46, ceasing to maintain a plan. Local authorities can cease a child or young person's education healthcare plan for the following 3 reasons: no longer require the SEN provision, over 18 years of age where the educational or training outcomes specified have been achieved, or over 25 years of age. Children and Families Act 2014, Section 49, Personal Budgets and Direct Payments. Pupils and students with education care plans are entitled to direct payments in lieu of SEN provision in school and college. However, local authorities and the school or college must provide authorization. The direct payment must only be used for SEN provision in the Education Healthcare Plan. Local authority will monitor SEN provision arrangements. There may be some good reasons for why disabled children and young people want to have direct payments. Here are a few examples. Disabled person may have a direct payment to employ personal assistants to provide personal care at home. A disabled person may want to increase the hours of a personal assistant that they trust to provide personal care in the college setting. A disabled person may want to employ the same staff for both the work and study related activity as part of their apprenticeship program. A disabled person may want to pay for software or hardware that will be compatible with their technology and equipment used at home. Children and Families Act 2014, Section 51, Special Educational Needs and Disability Tribunal, SENDIS, remit. Parents and young people have a right to appeal to the Special Educational Needs and Disability Tribunal if they disagree with the local authority's decisions made around their education and healthcare assessments and plans. The SENDIS panel consists of an independent qualified lawyer and an SEN expert. It is important to note that an appeal normally needs to take place within a certain amount of time. Parents and young people can challenge local authorities' refusal to carry out an education healthcare needs assessment, local authorities' refusal to reassess, local authorities' refusal to issue an education healthcare plan, local authorities' refusal to amend an education healthcare plan following a review or reassessment, local authorities' decision of ceasing to maintain an education healthcare plan. Children and Families Act 2014, Section 51, SENDIS remit covers challenges to the contents in the child or young person's education healthcare plan. This includes child or young person's SEN description, specified SEN provision, school or other setting named in the child or young person's education healthcare plan, the type of school or setting, or no school or other setting is named in the plan. Children and Families Act 2014, Section 51, SENDIS may order local authority to do the following. Education healthcare assessment to be completed, education healthcare plan to be issued. Make changes to SEN description, SEND provision specification, named education provider, or continue to maintain the education healthcare plan. Children and Families Act 2010, SENDIS powers health and social care provision in education healthcare plans, 2-year trial. Social care and healthcare aspects of the education healthcare plan, parents and young people must use local authorities and clinical commissioning groups' complaints procedures. However, SENDIS have the power since March 2018 to make non-binding recommendations about health and social care aspects of the child or young person's education healthcare plan. Children and Families Act 2014, Section 52 to 57, Independent Mediation. Young people and parents have a right to independent mediation to resolve disputes around special educational needs, health and social care provision with the local authority. There is a right for parents and young people to engage in mediation if there is a dispute between themselves and local authority around any aspect of special educational needs, health and social care provision. Non-engagement in mediation will not affect the rights for parents and young people's appeal being heard before a SENDIS panel. Children and Families Act, Section 60, Disability Discrimination in Schools and Enforcement. SENDIS panel can hear disability discrimination claims in school and make appropriate order. SENDIS panel can order the school to do something such as admit the pupil, undertake training or change a policy. SENDIS panel can order the school to stop doing something such as maintaining an existing policy. SENDIS panel cannot order financial compensation. Children and Families Act 2010, Section 66, Best Endeavours Secure SEN Provision. School or post-16 institution must use their best endeavours to secure SEN provision for children and young people with SEN. The school or post-16 institution must inform parents of child or young person of their SEN status and SEN provision received. Schools and FE institutions are only required to do their best in securing the SEN provision for their pupils and students with SEN. There is no legal definition of what is meant by best endeavours. Also, there is no absolute duty based upon schools and FE institutions to secure the SEN provision for their pupils and students with SEN. So in practice, some education providers will be better than others in both securing and providing consistent SEND provision for their children and students with SEN. Children and Families Act 2017, Section 77, SEN Code of Practice. The government is under a duty to publish a SEN Code of Practice that must be debated and passed by Parliament. The SEN Code of Practice provides guidance on how the SEN framework should work in practice. The guide covers all aspects of the law explained in this webinar. Children and Families Act 2014, Section 100, Schools' Duties towards Children with Medical Conditions. Schools are under a duty to make arrangements to support pupils with medical conditions. A child's mental and physical health should be properly supported in school so that the pupil can play a full and active role in school life, remain healthy and achieve their full academic potential. Disabled students in higher education are not covered by the Act. Disabled students' rights fall under the Equality Act. Higher education provision. For further information, watch the Equality Act webinar. Some disabled students may receive a disabled students allowance. Disabled students' entitlement to social care falls under the Care Act 2014. Disabled students' entitlement to health care fall under Health and Social Care Act 2012 and other relevant legislation. We hope you have found the ALLFIE's webinars training sessions informative. For more information about ALLFIE, visit our website www.allfie.org.uk, email us at info@allfie.org.uk, ALLFIE's Twitter handle, ALLFIE UK, ALLFIE's telephone number 0207 737 6030.